is I'm glad for you guys. Everybody made it. I know it's Merry Christmas. Let me first of all say that Merry Christmas to everybody.
Where's your hat?
What? Miss Glover, where's my hat?
You can have it if you need it.
Okay. So tonight's class is going to be on business, intellectual law, and human resources to that matter. So I want to introduce Hunton and Williams Law Firm, the big firm here in Dallas, and also had Mr. Fawaz here. Fawaz, come up and
Yep. Sounds good. Sure. So, hi guys. Thanks for having us here. We're really excited to present for you guys. We've got two great lawyers from our firm. One's from Dallas, one's from Atlanta. I'll let you guess who's from where. But they're both really great attorneys, in their practice areas. We've got Alan Marcus, who does employment law, and we'll be talking about that in the scope of small businesses. So it should be really relevant and pointed information for you guys, as well as Bob King, and he does IT law. And as small businesses, these are always topics that you have and questions that you have to consider while going through your process. So we hope it's a good presentation for you folks, and ask questions that you have. We have packets to give out as well. So without further ado, we'll have Alan Marcus go first for employment law.
Where do y'all think I'm from?
Georgia.
Come on! I was trying to put on my best
That was
Georgia
too deep.
accent.
That was
I think that's really
much.
Georgia accent.
It is. I say Atlanta. You guys
I'm from St. York, so
I
you need an accent.
am from Waco, Texas.
Are you serious?
I am
So
absolutely.
you're living in Atlanta?
No, I live in Dallas. I am 100% serious. So it's chilly tonight, yeah? It's chilly outside. I see like the fur and the hats and jackets. Let me tell you something. I was in Chicago last week for work.
That's where I'm from.
You're from Chicago?
Yeah.
It was so cold in Chicago that the lawyers had their hands in their own pockets. Who's got the drum? Let me tell you a real story. So, a guy that I know was playing golf, and he plays every weekend. And he hit his ball, and he sliced it, if you know what that is, over a hill on the right. And he couldn't see where his ball landed. So he is in a cart, and he's driving over the hill, and he comes up, and he sees a man laying down holding his head. And he rolls up to the guy, and he says, "Are you okay? Are you okay?" And the man says, "I'm a personal injury lawyer, and I'm going to sue you for $10,000 for the injury that you just caused me." And my friend, the golfer, says, "But I yelled 4." And the personal injury lawyer says, "I'll take it."
Jack no golf. Okay.
All right.
Okay, that's whatever.
Just a couple of, warm you up, right? All right, so I have practiced labor and employment law for 18 years. And in that time, I've always represented employers. And what we're talking about tonight, I understand that I've got you all till about 9:15.
Oh, yeah, that's your best joke, right there.
I didn't know how to laugh.
Something, Chicago. I do this every day. I talk to people every day. And there's really no difference between small business and big business. So I represent big box companies, Fortune 30 companies that have all kinds of problems. But it's the same kind of problems that you all have. Because employees present difficulties, and you don't want it to be that way. You can run your company, and you can run your business, and you make it feel like a family, but there will be something that comes up. And here's what got me interested in being an employment lawyer. My father was a small businessman. He owned a women's apparel store in Waco, Texas, and he had a woman that worked for him for 35 years, and she was family. She came to our home for Thanksgiving after her husband passed. She spent Christmases with us. This was salt of the earth woman. And she had an injury on the job, and filed a workers' comp claim. And my father did what a lot of small business people do, and that's go ask somebody who knows what happens. This is the first time that he'd ever had a workers' comp claim. He asked what they were supposed to do. The long story short is that the comp claim paid off. She got what she was entitled to. And then when she received her maximum medical improvement, that's a term of art in workers' comp law, when she received that maximum medical improvement and was released to return to work, she couldn't do what she was supposed to do. And so my father said to her, Mary, who was my grandmother's name, Mary, can you do what I paid you to do? This is the 80s. And Mary said, no, I can't do that. And he said, well, then it's sad, but I have to let you go. And so she sued him. And she sued my dad, and she sued him for workers' comp retaliation. That is a specific law under the Texas Labor Code, and that's the set of laws that the Texas legislature has set out that govern the relationship between employer and employee. And it was devastating to my father because this is a woman that he'd known for decades and somebody who I felt like was my aunt. And she was suing him. And it was painful for him, but it was a good lesson for him that he should not have gone into this without a basic understanding of the law, legal principles, who to talk to, who to ask the questions to, because the fact of the matter is you're all business people. You're not lawyers. And this is not something that you do every day. And the biggest problem that I see amongst my clients, be they Fortune 50 clients or the mom and pop shop, is that they like to try to handle things at the outset on their own. And so that's tough because you think you're going to save a couple of bucks by not talking to a lawyer, or you're going to do it yourself, or because this is a family business that things will just get handled because that's the way that they've always been. And this is the bear trap. This is where you walk right into it. And I want to make sure that you all understand and come away from this presentation, which is, you know, whatever. Bob's is a lot more exciting than mine. But, sorry. But you walk away from this presentation thinking, okay, I don't know all the answers, but I know that when I get into something, I better go ask somebody. It doesn't have to be me, but I better go ask somebody that knows. And that's the biggest part of this. So which laws apply to you? All right, most federal laws apply to employers with 15 or more employees. And I'm guessing that not all of you have more than 15 employees. You might, but I'm guessing that you don't. Not all of them. It's calculated company-wide, not by location. So if you were a restaurant business and you had 5 folks here, 5 folks there, 10 folks there, well, it's going to apply to you because we're going to calculate this on a company-wide basis. All right. Texas law, now I mentioned the Texas Labor Code before. Now, Texas law does not require you to have any number of employees, and this is why my father got sued, because he had 4 employees in that location. And he didn't know that under Texas law, you could be sued for the same things that under federal law, that's United States government law, that's what Congress twiddles their thumbs about, that Texas law provides almost identical protections to employees as federal law does. And then a lot of state laws overlap. That's what I just said. So Title VII, if any of you have heard of this, and we're going to talk about this, I promise, I'm not going to leave you in the lurch. Title VII of the Civil Rights Act of 1964 has the identical protections as what is provided under the Texas Labor Code. The difference between them is this applies to employers with more than 15 folks, and this applies to employers that have 1 employee. So the laws are the same. So here's where we get to the rub. Your best bet, always, is to approach everything that relates to employees and personnel as if the federal laws apply to you. That's the safest approach. You're really managing risk when you get into this area. And, you know, I've had several conversations today with different clients about issues that have come up, and you could approach it very aggressively, but you're begging a lawsuit. You're begging for somebody to say, you've done me wrong, I'm gonna file a lawsuit, I'm gonna see what happens. This is the better approach. It's good for morale to provide employees with the benefits that they're offered under federal law as well as under state law, and it's good for workplace productivity. You all may know this, but Title VII of the Civil Rights Act, as well as the Texas Labor Code, provide protections to employees based on race, color, national origin, religion, sex, including pregnancy, in some places, sexual orientation. So really all of the things that we have historically characterized as immutable characteristics, things that you can't change about yourself. Your race, your color, your national origin, your religion, things that you can't change are protected under the law. The Age Discrimination in Employment Act. How many of you know what age people are protected at under the Age Discrimination in Employment Act of 1967? Raise your hands. How many of you believe that it is 60 years old? Show of hands. That's where you can't be discriminated against because of your age. How many believe that it's 60 years old? 50? 50? How about 40? 40 years old. Now when I crossed that Rubicon of 40, I remember thinking I still feel young. 40.
Wow.
So the Age Discrimination in Employment Act says you can't discriminate against somebody because of their age if they are older than 40.
Wow.
If they are older than 40. And this really goes back to the 60s, frankly, when people lived shorter lives. Their working lives were shorter than they are today. And regularly in heavy industry that you wanted to move the old person out in favor of the young, more productive employee. And it's a holdover, and this is a lot of the stuff that I say about employment law. We deal with it. I'm jaundiced, I'm very jaded about employment law. You deal with it. You deal with what the federal law says or the state law says. Texas law on age discrimination is exactly the same as the federal law. You get very used to giving advice to clients based on what the law is, not what it should be. And you know, if my personal opinion comes into this, I say, not many 40-year-olds get discriminated against on the basis of their age. You might get a 50-year-old, you probably get a 60-year-old, a 70-year-old for sure. But generally speaking, 40-year-olds don't get discriminated against because of their age. It's a little silly. Nevertheless, we have to give the right advice, and let me just add something to this. A lot of times, my client will say, I've got a person that works for me, and this person is a poor performer, and we want to get rid of this person, but we want to let him down easily. We want to offer him a severance package. You've all heard this. We want to offer this person a severance package. It's going to be limited severance package. We're going to give him 1 month's worth of salary, and in exchange for that, we want him to sign a general release and waiver of claims in my favor that says he'll never sue us. He won't sue us for anything. Race discrimination, religious discrimination, ERISA, if you've all heard of ERISA. You won't sue us for age discrimination. But if that employee is over 40, the obligations of the employer are pretty different than if that person's under 40. So your 39-year-old, you might say to him, I'd like you to sign this release, and you've got 5 days to accept or decline my offer. But if you're 41, you've got 21 days. And if you sign it and later decide that it was because of age, you can revoke your acceptance of the offer for 7 days after you sign it. So you might end up with 28 days of not knowing what's going to happen next. So this is complicated stuff. All right, the Americans with Disabilities Act. You've all heard of this. This is one of those laws that went into effect for really, really noble purposes. And the noble purpose was, we shouldn't discriminate against somebody and prevent them a job opportunity because they're in a wheelchair, or they use a cane, or they're blind, or they're hard of hearing, or whatever. And over the years, so we've now been 27 years, this was signed by Ronald Reagan. In the 27 intervening years, it has been amended. And now we're talking about things that you can't visualize, disabilities that you can't see. It used to be that you said, okay, well, if you've got a handicapped parking spot and you've got the sticker in your window, it's because you were going to get out of your van and you were going to have a wheelchair, or you were sight impaired, or whatever it was. Now, virtually every medical condition can constitute a disability under the law. That means that if I wake up with a migraine headache tomorrow, and I'm not kidding about this, if I wake up with migraine and I call my employer and say, debilitating, can't come to work, that might constitute a disability. And no magic words are required. I don't have to say, I've got a disability. But you have accommodation requirements. You have an obligation to the employee that approaches you with a disability. And we'll talk about that more later. The FMLA, again, a noble cause. And I was just having a conversation about this topic today. So this went into effect under Bill Clinton, 1993. And at the time, and we can all appreciate this, that a woman who went out on maternity leave had no job protection. She could leave her job because she was about to have a baby, and they could replace her. And it was legal. Or she could come back and they could say, you know what, we don't have your job available for you. You can do something for $7.25 an hour. Or we're just going to get rid of you entirely. So the noble cause was, we have to protect jobs for people who are half of the population are women, and these are the only people that can give birth to children. And so we have to do something to make sure that our women in the workforce have the protection to come back to their job at the same rate of pay, doing the same duties, working for the same people that they had when they went out on the leave. And so, noble cause, but over the course of 22 years, things have changed. And so I'm going to go back up to migraines. This is my example that I like to use. The migraine headache is now something that might be used for an FMLA leave. Now, all that said, Texas does not have an FMLA, the Family Medical Leave Act. We do not have that. We don't offer job protection under our state law. This is a federal law. And you must have 25 employees to qualify under the FMLA. So unless you've got 25 employees, you do not have to comply. But it's a good idea, whether you're a 2-person business or a 50-person business, to understand exactly what your obligations are or might be under this law.
But if you have
Yes, ma'am.
25 and are in Texas, you have to abide by it, correct?
Yes, ma'am.
Okay.
Yes, ma'am. Okay, so basic stuff here. Whether you have 1 person or 1,000 people, it is a good idea to have policies. And I'm going to tell you why. When employees believe that they have been discriminated against, when employees believe that they have been done wrong, they file EEOC charges. That's with the Equal Employment Opportunity Commission. There's a state agency in Texas called the Texas Workforce Commission where they can file identical charges. So whether you are a 15-employer shop where you qualify for federal protection, EEOC, or less than 15, you go to the Texas Workforce Commission. And every time that an investigation is conducted by either the EEOC or the Texas Workforce Commission, they want to know, first off, do you have a policy that prohibits discrimination? Because if you don't, we think that you are not on the up and up. So everybody ought to have a policy. And I think you all are gonna get this presentation, and I don't have to read this, and we don't have to belabor it, but the long story short is, you need to say that you don't discriminate against any immutable characteristic, any of these things. You have to have that. You need it. You need an employee handbook, frankly. You need something that says, here are my guidelines. It's not a contract. These are my guidelines, and I rule the roost. I'm the one that sets the policies and dictates what happens at this place of business. But you need to have it.
May I ask a question?
Yes, ma'am.
As far as like the handbook, if you get one, I know I Google a lot of things. Where do you suggest that we find one that's like affordable?
There's so many resources. I think that the best thing to do is to go into Google and do Texas General Employment Handbook. I use Google as my research tool all the time. I mean, it's really invaluable. It's changed the practice of law. In my period of practice, things have changed drastically. And the way I use Google now is the same way that you all use Google. I mean, there's really no difference. I guess the difference would be that I've been a lawyer, and so I kind of know what I'm looking at. But that's a good place to start, and you'll find a lot of samples. People put their stuff out there. The Society of Human Resource Management is an organization, shrm.com, is a really good source for information. Now, you have to join SHRM, is what the acronym is, to get access to everything that they've got. But if you've got human resources issues or things come up that you're thinking about, that's a good place to go. I don't think that the dues are outrageous, and they provide a lot of the stuff. They don't provide the legal insight, but they provide you with materials that you might need.
What was it called again, please?
SHRM, shrm.com.
Okay.
Okay, so when we talk about the Americans with Disabilities Act, we are really talking about what you're obligated to do when it comes to accommodating an employee with a disability. Let's use migrants, okay? And let's say that the employee approaches you and says, I've got these debilitating migraine headaches. And my doctor has told me that my job exacerbates those migraine headaches, because I hear this a lot. And my doctor says that I can't do this office work anymore. And you may say, you can't work here if you can't do that. Well, that violates the law. Your obligation is to engage in what is known as the interactive process. All this legalese, I know, believe me. The interactive process means that you are sitting down with the employee and you are talking about things that you can do or that the employee can do to perform the essential functions of the employee's job. So let's say that you got a bookkeeper, and the bookkeeper works in a back office in fluorescent lights, and the bookkeeper has the migraines. And the bookkeeper says, can't do this, there, under these lights, migraines, all that stuff. And you say, okay, what is it that you would like us to do? There are no magic words required. What is it that you would like us to do? And the employee says, I want to work 1 day a week. You say, can't do that, need you here 5 a week. But the employee says, well, what if I was able to work from home the other 4 days? You have to at least consider that. You have to document this, you have to consider it. Whether it's reasonable, whether it works for your business, I don't know. But you have to consider it. And if the employee said, hey, listen, it's the fluorescent lights that make my migraines worse, then what you might have to consider is, let's put in some different kind of lighting in that office, unless it constitutes what's called an undue hardship. And an undue hardship is something that is cost prohibitive. You can't do it because retrofitting your space would be cost prohibitive. That's more than this business brings in a year. But believe me, the EEOC and the Texas Workforce Commission take a very dim view of employers that say no. No. You have to sit down, you have to talk about it, you have to explore options, you have to explore different positions, open and available positions in your business for which the person qualifies. I had a lawsuit, this was the first lawsuit that I ever tried to a jury trial. We had an employee who was an electrician for a big company for over 20 years. And in that role, he climbed, he crawled, he stooped, he bent, he used his hands, he used his feet and his legs and everything else to work on equipment. He also used a computer terminal to troubleshoot. So he would see on the big screen where things were going wrong. And he would go out, he would figure it out, and he would go fix it. Now, he was one of 40 electricians that worked for this company. And they were all doing the same thing, and they were on different shifts. So he goes on vacation, and he's riding a mountain bike in Arizona. And he falls off the mountain bike and breaks his neck. And he is quadriplegic at that point. Severs his spine. So he is on a leave of absence for a long time before his physician says, I'm releasing you to return to work. Now, he can no longer go out to the field and use his hands or his legs or climb or crawl or any of that stuff that he'd done before. But he says, I can troubleshoot. I can sit at the computer terminal and I can see where things are going wrong and I can dispatch somebody out there to go fix it. And the company says, no. You can't do that because those aren't the essential functions of your job. The essential functions of your job are troubleshoot 1, fix number 2. We're not hiring somebody else that you can dispatch to go fix what you have troubleshot. So he files a lawsuit. Now, I don't disagree with the legal premise. Those weren't the essential functions of his job. It was not simply sitting at a computer terminal. I agree, legally. What I disagreed with, and where we got in a little bit of a pickle from a legal perspective, is not exploring other options. Maybe you shouldn't be an electrician. Maybe you should be an HR generalist. Maybe you should be whatever open and available positions there were. The problem that they had was that they never explored any of those options. They didn't talk to him about a single open and available position in a company location that had over 2,000 employees and 250 different positions, of which there were a dozen openings at the time that they said no. That was their problem. So you have to think about that. The same, yes ma'am?
When, say somebody has an accident and the employer does explore those options, do they have to find a position that's at the same salary? So if he were moved to a different place in the company, would they have to then say, this is a customer service position, yes, you'd be sitting at a desk, but instead of $80,000 a year that you were making as an electrician, will he make the same thing as a customer service rep? Or will he take a pay cut?
Jasmine has asked an awesome question. The answer is no. You do not have to keep that person at the same salary level. If they can't perform the essential functions of their $80,000 a year position, but they are able and willing to do a $40,000 a year job, you can put them in that if they accept it. A lot of this is posturing. I don't have a better way to say that. A lot of it is presentation. My goal when I'm advising an employer is get the employee to agree that this is what they're going to do, and get that in writing. We're going to talk about writing later, but get it in writing. Get the employee to agree and acknowledge, I can't do this job, but I can do customer service. And have them sign off on that, because that's your exhibit A when the employee comes back and says, hey, I believe I was discriminated against. So that's something to think of. Does that answer your question? Okay. So, and by the way, feel free to ask questions, interrupt me, because I'm really long-winded, and we really will go till 9:30. just leave me my devices. All right, religious accommodation. This is a hot topic right now because of religious garb in the workplace, and sometimes it's food safety issues, sometimes it's presentation to clientele if you're customer facing and you have tattoos, or if you wear jewelry that a customer might find offensive. But it's the same, it is exactly the same analysis. Can you perform the essential functions? Can we provide an accommodation? So the question that I had last week was, our 2 employees have started doing prayers 5 times a day. And during their shift, it is twice. And the problem that we're having is where they're doing it. They're creating a impediment to free passage through the area. And do we have to let them do this? And the answer was yes, you have to let them do this, but you are entitled to provide them with a place where they can do it. The more frequent question, the one that I've gotten most frequently in my career, is an employee has suddenly decided that she goes to church on Wednesdays, or he can't work on Saturdays, or whatever it is. And the standard is, if it is a sincerely held belief, and you can't second guess somebody's sincerely held belief, if it is a sincerely held belief, you must accommodate. You are required to accommodate.
Wow.
All right, FMLA, I mentioned this before. For those of you that don't have, I said 25 to 50. For those of you that don't have 50 employees, this is not as relevant, but let me just give you a high-level sense of what the FMLA does. If an employee has a serious health condition, or their spouse, or their child, or their parent, or their sister, or their brother has a serious health condition, you are required to provide them with 12 weeks of unpaid leave on a rolling 12-month calendar, or a calendar year, depending on how you calculate it. I know this is ridiculous. It can get way over the top complicated. To provide medical care for their own or someone else's serious health condition. What is a serious health condition? Virtually anything. There's also this notion that somebody can take intermittent leave. That's not 12 consecutive weeks. That is, I'm taking half day here and half day there. Think about dialysis. Somebody that receives dialysis doesn't do it for 12 consecutive weeks. They do it for the rest of their life, twice a week or 3 times a week. And so they need a half day off here and a half day off there. And so if you were obligated to provide FMLA leave, you would have to count it in the lowest increment, bear with me, the lowest increment at which you count time off. So if you do 15 minutes at a time, you must count FMLA 15 minutes at a time. If you do half days, it would be a half day increment. If you do full days, it's a full day increment. The Department of Labor, who governs all this stuff, says we really don't like anything more than a half day. So half day is kind of our standard that we use. Here's the reasons: care for a child, that was the original reason. Here's what's happened since then: serious health condition, care for spouse, son, daughter, or parent who has a serious health condition. And like I said, serious health condition is
It's not brother or sister, though, is it?
It is. It is.
So I can care for my sister.
Yes.
I didn't know that.
Yes. Okay. USERRA. Who all has heard of USERRA? The Uniform Services Employee Return Act. All right. It's almost identical to FMLA. The standards are the same. It was kind of an afterthought. It was, if you've got an employee that is doing military service, you can't discriminate against them. You have to hold their job open. You have to keep them in the same position. You can't drop their salary. You can't replace them. Same thing. Same eligibility criteria apply here. 50 employees. You just can't discriminate. Also, if you have somebody that is on reserve status or active status and they have to leave because they're going to be deployed, you gotta let them do it. You can't say, hey, you're fired. Or you can't say, really, that doesn't work for us right now. So you gotta let them have the military leave. I mentioned this before, employee handbooks. I think that really your best bet is to do one, is to find one on Google. This is important, and let me, I hope not to tangent here too much. There's been a lot of chatter, at least in my world, recently about the National Labor Relations Board. The NLRB is the organization which was chartered in the 30s to prevent employers from discriminating against employees working together, at least in part, towards bringing a union in, okay? And the National Labor Relations Act protects certain activities of employees to get together to talk about working conditions and wages, supervisors. They can say bad stuff about supervisors together and we can't retaliate against them. But the board has been really active lately outside of the union environment. Historically, and I say for 80 years, the board limited its review and scrutiny of anything that happened in the workplace to employers who had labor unions. And now they've stepped out of that and they've gotten into the world of non-union workforces. And they started with employee handbooks. And the reason that they started there, and social media, which we'll talk about, and the reason that they started there is because this was a topic that was so easy for them to grasp and kick. It's the lowest hanging fruit. You've heard that expression, the lowest hanging fruit. It was an opportunity for the board to say, you are violating employees' rights by telling them that they're not allowed to talk about salary information with each other. You don't want your employee, nobody wants their employees to say, hey, I got a $5,000 bonus, what'd you get? Because then the natives get restless. And employers have, for time immemorial, said, don't talk about salary. Don't talk about salary. That's against the law. You're not allowed to do that. You're not allowed to tell employees, don't talk to your coworkers about how much you make. So they started picking on employee handbooks where a lot of those policies were found, and they picked on a couple of different topics. One was the at-will status. Two was confidentiality. And the reason that they picked on confidentiality is because they said, you tell an employee that he's not allowed to talk about salary for one, or an internal matter for two, or anything else really. And that prevents him from exercising his rights to go to Lakeisha and say, I'm really ticked off about the meeting that I just had with Joe. Joe said X, Y, and Z. What's your opinion? Because that's my right. It's my right to go to Lakeisha and talk to her about what I'm angry about. So the board has picked on this stuff. So you have to be really careful, but at the same time, you need a statement that says, this is not a contract. We're just providing a guideline for what it is that we do here at this business. You are employed at will. So raise your hands. Who knows what at will means? What does that mean?
That you don't have a right to be here, I can fire you.
I could look at you and say, I don't like people that wear green. You're not wearing, who's wearing
Santa
green?
hats.
Nobody's wearing green. Green is the one I always pick. Nobody's wearing green. I don't like people that wear, well, that sounds religious.
Oh,
I don't like people who wear green. I'm picking something just completely mundane.
because that could be.
You're fired. And similarly, you have the right to say, I don't like guys with really scraggly beards. I don't want to work for you anymore. And you can leave, and I can leave, and we can part ways. That's what at will means.
Bad jokes religious?
What's that?
Bad jokes?
Bad jokes for them. Where's your drum set? So that's what it means, but it doesn't really exist in reality, because every time somebody gets fired or an employer calls me and says, can we do this? You're still looking at the fairness, what I would characterize as the equities of the situation. Is this the right thing to do? Should you? Should you fire somebody for this? Can you? Yeah, of course you can. I never say no. Can you fire somebody for wearing a green shirt? Of course you can. Should you? Probably not, unless you got a better reason than that. And the rationale here is, imagine yourself in front of a judge and a jury, 12 peers, who don't know you from Adam. And they're sitting up there, and you're explaining the reason why you fired Jim. Jim was wearing green, hate green. That sounds ridiculous. Jim says, no, it's because I'm 41. That's why you fired me. And that sounds more plausible than Jim wearing a green shirt. So that's what at will means, but take it with a grain of salt. You're not creating a contractual relationship with your employees, but you're making absolutely darn sure that they don't think they've got guaranteed employment. This is not cradle to grave employment. You are here to do your job. So long as you do a great job, you're here, you're going to be rewarded for it. When you do a bad job, I have the option, but it better be a good reason, and you better document it. Change, modify, do all those things. You have to reserve rights in these documents. I had a lawsuit in Oklahoma. I was a baby. I was 26 years old, I think. And this lawsuit was brought by an employee who said that the company that fired her during her probationary period, and I'll talk about that just a little bit, during her probationary period, breached their contract with her by not giving her progressive discipline. Progressive discipline?
Yeah.
Written warning, verbal, written,
Right.
They just fired
Step
they
one,
terminated.
step two.
decision-making leave, maybe, and then you're fired. Okay, so that's all a bad idea. Progressive discipline is a bad idea. You just have to be consistent. With whatever discipline you give, you just have to be consistent. You just have to treat people the same no matter what. But you don't have to have steps, because steps look like a contract. Steps look like an obligation. Steps look like a union contract, actually. So she files the suit. She says, you breached the contract because you just fired me. You fired me on the 89th day. 90th day was going to be when I was in there and vested in my right to be employed here. And ultimately we prevailed, but it was this ridiculous case. And her attorney has since been disbarred, which is great. But you know, it was the notion that my client had this ridiculous handbook with this overwrought progressive discipline practice, had her thinking they were obligated to do it. So I always want you to know that you don't have any obligations to do anything a certain way. You can be who you want to be in your employment documentation. So I said that I was going to say a word about what topic did I just say? It's not a quiz. What did I say I was going to talk about?
Handbook.
No, before that. I said I had a topic about, probationary period. They mean nothing. It means zero in the law. I don't care if you do them. I don't care if you don't do them. They don't mean anything. An employee is an employee is an employee. An applicant has the same rights as an employee. An applicant comes to you, says, I want to apply for a job with your hair salon. You look at that person, you say, your hair is a complete mess. There's no way I'm hiring you. He turns around and says, you discriminated against me because I'm a man. Applicant has the same rights as an employee, be they probationary or otherwise. So that doesn't mean anything. If you all use this concept of you're probationary for X number of days, months, weeks, whatever it is, it doesn't mean anything.
Using what you just said, if a person has excessive tattoos, and in the interview, well, you just don't tell them, you just don't hire them. Is that what you're saying?
I'm
You
not-
can't say, I'm not hiring you because those tattoos, I'm just not.
Well,
doing
look, so if a person doesn't present the image that your business needs to project, you might have a legitimate non-discriminatory reason to not hire that applicant, right?
it. Right,
Okay? It's not based on race or gender or national origin or religion or disability or veteran status or any of the other protected
Right.
categories. It's based on you not being the right person for this job. That's okay. But if the reason is because what he's got on his arm is, I don't know, a big cross,
Mhm.
and you say, I don't ascribe to your religious views, and that's the reason you don't hire him, now you're in trouble.
Okay, you don't mention anything like that, just tattoos,
Yeah.
period.
The,
Just like the hair was messy.
the thing
You
is,
see
you
what I'm
just don't
I do.
say, cause when you're
Right.
interviewing, you just don't say, that's, in the interviewing
couldn't.
process, you just don't say. You don't have anything to say about, that's not a part of the interview. The looks, the appearance is not a part of your interview.
Right.
Your, the
Unless I've got messy hair.
qualifications, the qualifications of that position is what you're interviewing for. And even in an interview, we don't discuss what we're interviewing for. You have certain criteria that you're looking for in that interview. And the interviewing process, I'm looking at your appearance, but I'm not stating that out loud.
Yeah,
I
that's what I
may-
mean.
Mentally, I'm taking note of that, and mentally, but I'm not gonna say it because that's gonna put me in that position to
The
where.
fact of the matter is, I'm not getting hired by
I don't think
Lakeisha.
so either.
He doesn't think I've got the qualifications.
I think the question is, if the applicant comes to the interview and they're completely covered and they don't seem to have any tattoos, but they show up the second week of the job, and now they decided to get a tattoo covering half of their face.
Right.
Like, does the employer have any recourse to say, I don't think you're right for the job based on the tattoo that's covering half your face?
So we're back to the accommodation standards. We are looking at, is that tattoo religious? If it is, then we've got something to think about. If the tattoo is, just whatever, like he's covered his face in red and it's not religious, then I think we're at, I can't put you in front of a client. I can't put you in front of a customer. And so I can't use you here. But you have to use your best judgment on that. And sometimes it requires the sit down, the conversation. What is it that you've covered your face with there, Mark? I mean, what's that all about?
Yeah.
Yeah. All right.
Oh, so-
I went way too fast. I am a novice at this. All right, supervisory training. Folks that you have that work for you that are in lead or management type roles ought to be trained and told about these things, because that's your first line of defense. And the vast majority of employment lawsuits don't come because the owner did something that the employee disagreed with. It's because of the person that they report to has gone way over the top. So, very quick tangent. I represent on a pro bono basis a very useful service organization in Dallas, in South Dallas. And they do really good work in the community. And I appreciate them, and I think the world of them. They tend to hire not great people. They kind of get out there and they open their doors, and whoever wants to show up, that's who they end up with. So they ended up with a guy who they weren't really watching, and he supervised a group of women, all of whom he sexually harassed. All of them. The text, pictures, and the whole 9 yards. It was really ugly. So the way that the employer found out about this is because the first of the 3 women that he supervised comes into the HR office and says, I'm leaving. I'm going to work for so-and-so. And the HR person said, as she should have, why? And she said, I just think that this is a better opportunity. And oh, by the way, Stanley has been sending me pictures of, you know what? And so HR says, I need more information. Explain, I need to investigate. Very long story short, all 3 of the women reported the same set of issues with Stanley, and the photos and the comments and this and that. Stanley was a supervisor. So supervisors speak for the company. They can bind the company legally. So they were kind of out of luck when it came to liability. They were liable for Stanley's conduct. It wasn't ratified. It wasn't the kind of conduct that the company said, oh, yeah, we want Stanley. Send pictures. I mean, gosh, do that all day long. It was, Stanley's a supervisor, and Stanley did what he did. So it was a little bit of a struggle, but what I told them subsequently was, let me come out and talk to your supervisors once a year, just so we can check the box and say, you are held to a standard here. Believe me, this job, your responsibilities, the salary that you make, comes with a high level of responsibilities. And let me tell you what's not going to be tolerated. This is important, and whether it's formal or informal, if you've got supervisors and managers that work for you, you need to check that box, because secondary to the EEOC saying, hey, show me your EEO policy, secondary to that, the next thing they want to know is, when's the last time these folks have been trained up? So you need to make sure that you check that box. Okay, this is the hottest area of the law. And this is one, and I promise you, I am not fudging when I say this. I have never one time in my entire career looked at a personnel file that did not have mistakes in wage payment. Not one time. Not one time. I promise, no fudge. The Fair Labor Standards Act is really complicated. It's really dense stuff. This is a 1933 law that governs who's exempt from overtime, who's not exempt, and what the standards are. And as you all know, if you are not exempt, you get paid time and a half for hours worked over 40 in a work week. The reason that it's hot is because plaintiffs' lawyers can file these cases, file class action cases with one person saying, this person is similarly situated to the entire class of individuals who might have been paid wrong, and they can just sit back and wait for the money to start rolling in. It is the easiest stuff to do. Your pay practices are the lifeblood of your organization, your business. You better pay right. You better get this stuff right. This is extremely important. I'm not going to belabor the details of it, but determining exemption, non-exemption, your supervisors are exempt. You don't pay them overtime. Work 60 hours, you get paid the same thing. You get paid on a salary basis. If you're the cashier in your restaurant, cashier, hourly employee. Hourly employee. So your cashier works more than 40, time and a half.
And if they take something home, it's time and a half.
That's right. You
My
better
company
not
got
let them
sued
work
for
off
that.
the clock.
Right.
I got like an hour. Seriously. All right. So immigration and citizenship issues, I-9 forms. This is a big deal. The Department of Justice handles immigration and naturalization and I-9s. That's big, big stuff. I don't know if any of you run background checks on your employees before you hire them, but that's governed by the Fair Credit Reporting Act. Specific stuff. You got to tell them. You got to give them an authorization. They have to sign it before you run a background check on somebody. Determining whether somebody is suited to the job based on the outcome of a credit report or a background investigation is governed by very, very, very specific rules. Here's the rule of thumb. If the conviction that that person has on their record does not relate to the position for which they've applied. Let me give you an example. And it's the most grotesque example. Somebody applies to be a bus driver. He has been convicted of child molestation. I'm pretty sure that you can disqualify that person for the job. However, if somebody applies to be the cashier and she has been convicted of drunk driving, I'm not sure that that relates. Can you use that as a basis for disqualification? Not all convictions relate. How about a 20-year-old murder conviction for somebody that applies to be a cleaning crew? Does a 20-year-old murder conviction for which that person has served time relate to cleaning crew? It's a big question. There are a lot of employers that look at it and say, I don't want that person here. That's tough stuff. This is gray area. There's no what I would call the bright line test. You know, yes, no, bright line. We know one way or the other. There's no bright line for this stuff. You just have to be really careful. It better relate to the job, and you better be consistent.
What about credit report?
Same thing. Like, does the credit report, so you have a bank and you run a credit report on your teller and you find out that he's been in bankruptcy 3 times,
Oh, yeah.
okay? I can kick him out because I've got FDIC issues and all kinds of other stuff. But you run a credit report on a custodian or a cashier, and the credit report reflects that you have a 410 score. Is that a basis to disqualify that person from the job? I mean, I don't think it is. It depends. It depends. You're a cashier, maybe. You're dealing with money, maybe. That'd be a question to ask somebody. Okay, so if you provide benefits, just be aware that stuff under the Employment Retirement Income Security Act and the Internal Revenue Code is uber specific, uber specific, very technical. You don't have to go to a lawyer on this stuff, but you gotta have an accountant, as I'm sure a lot of businesses do, have an accountant, somebody that knows what they're talking about when you're setting up benefit plans. Workers' compensation, we talked a little bit about that before. You either have it, you are a subscriber under Texas law, or you are a non-subscriber. And if you're a non-subscriber, you are potentially liable for an employee injury on the job out of your own pocket. If you are a subscriber, you pay into the scheme, then the Texas Workers' Comp Board handles all of the compensation issues that happen because the guy slipped and fell working on the grill, right? Slipped and fell, and if you're a subscriber, then that issue gets handled outside of you. You have a third-party administrator. The third-party administrator handles all the claims. Unemployment compensation, employee loses their job. There are only 2 reasons that that person is disqualified from receiving unemployment benefits. Either they were fired without cause. They could be the worst performer in the world. You're terrible, you don't show up, you are horrible when you get here, you're still entitled to unemployment benefits. But if you stole from me, or if you got in a fight at work, or you talked back, or you swore me out, or whatever it was, you're disqualified. The second reason that you're disqualified is you quit. You quit. You called me and you said, I'm done, I'm not working this job anymore. Accidents and injuries, OSHA, if you've got more than 10 employees, you are required to keep records of workplace injuries. That is a technical requirement. If you're ever audited by OSHA, they will pop you if you have not kept records. I know, it's like, why do I want to own a business again? This is really, this stuff, enough of this, right? Record keeping. So all of these laws require record keeping. Here's my best practice. Keep employee records for 3 years after somebody's terminated, after they're gone. Keep them for 3 years. Required postings and notices. I bet all of you have this. You can go to the Texas Workforce Commission website and they make an all-in-one poster that you have to post in a conspicuous place, and it contains all of the laws that you're supposed to notify employees that they are protected under. Interview questions. I don't know who came for this, but interview questions. So permissible and impermissible. Who knows why this is impermissible?
Which one, how old are you?
Yeah, how old are you? Okay. Do you plan to have more children? I mean, this is stuff, this is really common sense stuff, but a lot of folks get this wrong. Permissible and impermissible. If you disclose a disability, then you need to start the interactive process. Factual, accurate, contemporaneous, thorough, sarcasm-free. This is in conducting any kind of investigation, and really this is kind of a big point. What I'm really looking for you all to do is document your processes. And this is evaluations, this is interviews, this is anything that relates to the employee-employer relationship is documented. preparing a disciplinary report. You all can see this, I don't need to read this stuff. All right, email, big topic, because social media and email, here's how I like to think about this. What you say in an email to your colleague, to your co-owner, to your spouse, to your boyfriend, whatever, is the stuff that is discoverable in a lawsuit. Anything. What's not discoverable is what you send your lawyer. It's not discoverable. So if you send it to your lawyer, whether it's your family lawyer, your tax lawyer, whatever, it's not discoverable. It's privileged under the law. You got to be real careful with email. Most of the lawsuits that I have that I tell my clients we got to settle get torpedoed because of really bad emails. Really bad emails where HR manager sends to supervisor an email that says, how can we get rid of her? I'm going to give you an example, I promise. All right, mediocre Mary, she's pushing it to the brink, terminated for insubordination. You meet with Mary to discuss her. Are there any problems with this? She yelled, she called you an idiot in front of the entire staff. She's always been satisfactory or average. Is there any problem with this? I know I'm giving you really short shrift here. Have we documented this enough? Mary sues the company for sex discrimination. Here's exceptional ed. Why did a man get away with essentially the same thing that you fired Mary for doing? Emails come into the picture. What are you going to tell the attorneys? Are there problems with your story? You got to think about this from a documentation standpoint. All right, here's the email. And this is cribbed. I promise you this is cribbed from an actual case. Thanks for your advice about Mary. I was sure I could terminate her for insubordination. I am actually relieved. I've been looking for a reason to replace her for some time, but I didn't have the heart to terminate her because she had not done anything awful. And she seemed so depressed. She seemed so depressed and unstable. I mean, that red flag after red flag. I didn't want to be the one to push her over the edge. Maybe this will help end up being a good thing for her. If she gets some help from a shrink, she might be able to turn her attitude around and be a good person. So this is.
We're gonna get started with Mr. King, so let him have you guys under my attention. He flew all the way in from Atlanta. So
and boy are my arms tired. We're going to jokes. Right, so I've been challenged by Alan for a joke before he leaves. And I'm a patent attorney. If anybody know what a patent attorney is? What they do, or the definition of a patent attorney? Well, a patent attorney is somebody who doesn't have enough personality to be a tax advisor. Generally. So,
Hey, that was a good joke.
all right, there's another good patent attorney joke. What's the difference between an introverted patent attorney and an extroverted patent attorney? When an introverted patent attorney looks at his shoes and he's talking to you, an extroverted patent attorney looks at your shoes and he's talking to you. That's as good as it gets. So anyway, thanks. So yeah, my name's Bob King. I'm in from Atlanta. I'm a partner of Hunt Williams with Alan. I've been doing patent law and intellectual property law for about 18 years. And there's a lot of misconceptions about what intellectual property is, what the different kinds are. You hear a lot of people say, oh, there's Cam Newton's trademark touchdown dance, or you hear somebody get a copyright on this. And there's actually a great scene in one of the Batman movies where somebody picks up a phone and says, get the copyright office, get the copyright office on the phone and you get patent ASAP. And those kinds of things. A lot of people don't necessarily understand what they are. And there's actually a number of kinds of intellectual property. And probably the most relevant to this group are probably the trademarks, and also probably avoiding people's intellectual property. But we'll get into them and kind of give an overview. I don't think it's going to be quite as exciting. I'm not going to have as many war stories that are interesting because generally it's a kind of boring subject. There's not a lot of human interactions, not a human stories on the line. It's more about protecting ideas, protecting property, and those sorts of things are very important, but there's not really a human element involved. So these are the types of intellectual property. There's 4 common types. The first kind is a trademark, and you can think about it, trademarks all over the place. Things with a circle R after it, or a TM, and we'll go into the difference in a couple minutes. But basically, a trademark is a source identifier. And the reason it's called a trademark is back in the colonial days, or even the Middle Ages, I guess, when somebody built something, like a blacksmith made something, he'd go ahead and put his little stamp on it. is a source identifier. So people said, oh, look, Joe the blacksmith made this. I know Joe the blacksmith makes great stuff. Problem is that people, Sam the blacksmith, who isn't very good, started using Joe the blacksmith's mark, his little J on it. People would get upset because they think, well, you know, I got this from Joe, and it's not. I got this from Sam. It says made by Joe, but it's not very good. So that's where whole trademark protection comes in. To protect the source and to protect the goodwill and the businesses that invested a lot of money in their marks. Copyrights. Copyrights are protecting artists' fixed impression. So it's more like a book, a picture. I mean, how many people know that if somebody takes a picture of you, they own the rights in that picture? When your kids go to school and there's pictures taken and they say, you know, go ahead and buy the picture, even though it's your kid, they own the rights in the picture. So if you want to get, you know, legally, you want to get a copy of the picture, you just can't just scan it. You've actually got to buy the rights to the picture from them. And that's a lot of times they'll sell to you on a digital, you know, on a USB card or something like that. Patents, that's what I do. Patents protect, there's a couple different kinds. Patents protect functionality. There's patents on, for example, on vehicles. There can be a patent on a tire. There can be a patent on a computer program. That's normally something you think about copyrights for. But, like for example, that camera right there is probably patented. There's probably several patents. It can cover things from batteries. It's basically something that somebody invents. There's plant patents that can protect new sorts of plants. And there's also design patents that are similar to trademarks. They can cover basically the ornamental aspects of something. So, for example, if somebody came up with the newest rage is web pages, Google actually has a design patent on their interface. The design of their web page, where you've got the search box in the middle, the Google logo on top of it, they own that. So no one else can go and actually copy that exact layout for a certain amount of time. Finally, there's trade secrets. Trade secrets are something, the most famous one is the Coca-Cola formula. It's something that a company invests a lot of money in, and they don't want anybody to know what it is. So if you go from Atlanta, they've got the Coca-Cola Museum there, and it's funny because they've got, you know, the vault where apparently the Coca-Cola formula is. Who knows if it's actually there, if it's just show and tell. But basically what it is they've instead of disclosing their trade secret, their formula for Coca-Cola to the world, and trying to get patent protection on it or something like that, they decided to keep it a trade secret. They protect the formula from anybody knowing about it. They've sued employees who have tried to take it before to go ahead and say this cannot be out in the public domain. This is ours. If you know Pepsi, if you want to try to copy us, you can do whatever you want, but you can't have our actual formula. We're not going to give it to anybody. So let's start with trademarks in more detail. These are some common trademarks: IBM, Apple, Nike, McDonald's, Google. There's a couple ways that the trademarks are identified. One is by a TM, and that means, and anybody can do that. If you have a good or service identifier, you can put a TM after it. That just means I'm claiming rights in that particular mark. It might just be a common mark, it might be local. Once you file a registration with the Patent and Trademark Office, it gets examined, and then it will be issued as a registration. And you'll see if anything has a circle R, like that, like that, like that, that means they've gone through the process, and it gives them certain advantages. So for example, if somebody tries to import something in the United States from Apple with that logo on it, Apple can go to customs and say, hey, confiscate that, and they will. That's a lot of the things like, for example, if you go to New York City, you see fake Rolexes, fake Louis Vuitton bags. Those are all counterfeit because there's actually registered trademarks in those. And if if people knew they were coming in, customs could go ahead and actually confiscate those goods. And then SM, service mark, not as common, but it's more of a saying, a slogan.
I have a question.
Sure.
If my company name is Majestic Money Management, my trademark is Your Financial Name. Is that a service mark or a trade?
What's your actual mark?
Your Financial Name, and
Okay.
they wouldn't let me use Mary Poppins, so I had to create it.
You could actually claim that as a trademark. It's got to be something that actually, and it could be either actually, to tell you the truth. It depends on, there's a really fine line between the two. I would personally, I think it's more of a service mark than is an actual
Right.
trademark because it's identifying your service you provide. And we'll go into in a couple minutes about the best way to make sure to use your trademarks, because there's all kinds of pitfalls in how if you use your trademark or your service mark incorrectly, you could actually lose rights in it.
Okay.
So what is a mark? Mark is any word, name, symbol, or device. It said it serves as an indicator of origin. McDonald's, IBM, Apple, Firestone. Houses goodwill. That's a key. It's basically you're saying I have invested a lot of time and effort, money, whatever happens to be, into developing this brand as a source of a good or service. And when people see this mark, they associate it with my goods or service. I've established, I have their goodwill, the public's goodwill in my mark. And again, it can be common law, such as just by using it in commerce, you get a mark in whatever you're using, or it can be federally registered, which is actually, we have to go through the process. So even if you didn't register your mark or with the state, you've got a mark.
Okay.
You're just by using that mark in commerce, you actually have common law rights in that mark. Now they don't go beyond the sphere of influence of which your mark is used in, whereas federally you get the entire United States.
I have a question.
Sure.
So, with the common mark, say you go to register for your LLC, and when you register with your secretary, say you also register for, you know, your trademark or whatever. If there's another entity or another business that takes your same name, but they're in a different state, how would that?
So if the entity is, let's say you've got your business in Texas and somebody in Arizona decides to have the same business, generally it's fine. Because there's not, the real thing is you're trying to protect against consumer confusion. So someone in Texas and sees your business is gonna say, well, I understand, you know, that's with Jasmine. And somebody in Arizona is gonna say, well, that's not Jasmine, because it's not in Arizona. If somehow the other company decided to get really big, and they started to use your business, aesthetic innovations, in Arizona, and got a federal registration for it, then you would still have your rights, your common law rights, and the other company would have the rights in the United States other than in your little area. So you would be, it really comes down to the first to use the mark in commerce is the one that usually wins those battles. So here's basically a rundown of the types of marks you use. Trademarks, most common. Service mark is more of a slogan. Certification mark, trade name. A trade name can be, you know, just basically a company name. McDonald's can be that for the business. Trade dress. Trade dress can be something like the packaging the product comes in, such as a Coca-Cola bottle is commonly thought about as having a trade dress, because they've established some sort of secondary meaning. It's a legal term, but they've established that if you see that bottle, that shape, you say Coca-Cola, and that's a whole idea. You're trying to establish something. It can even be color. It can be, for example, Owens Corning has a trademark on their pink fiberglass for housing. Because, you know, pink. Why would you have that? But they've established a secondary meaning that goes along with that. So if you see pink fiberglass insulation, think Owens Corning. A slogan, a collective mark, and domain names. Domain names can also be marks, although they're generally not federally registered. You register those with the Network Solutions or some other provider, GoDaddy, etc. So the advantages of promoting your marks is it attracts attention. So if you have a mark, something, you know, can be catchy, can be flashy, kind of sets your business apart from some of the other businesses that may be out there. The goal is to symbolize quality and it stores goodwill. Again, you want people to see your mark and say, aha, I've known I've had this before, I've gone to this particular business before, and it was great. Hopefully that's what they're saying. And I'm gonna recommend that other people go there, or I'm gonna buy other things that might use this mark as well. And it's like Coca-Cola when they're doing the clothing in the 80s, you know, they were trying to capitalize on their mark, or McDonald's, I think somebody had clothes, and, you know, trying to say, well, people are gonna say they like our soda, they're gonna think our clothing is the same high quality stuff that, who knows how that works. And the conditioned response. You're driving down the highway, you see McDonald's, you know exactly what it's gonna be. And that's the whole benefit of the mark. It's an indicator of goods, indicator of quality, and it promotes that association with the consumer, and the consumer goes to go ahead and buy something. So trademarks can apply to appeal to any of the senses. So again, like I said, you can have the site, you can have a design, you can have a word mark. Colors, you can get a mark in a particular color, you can get a mark in a shape. There's trademarks in some sound, like the Intel bum 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 bum, you can get a trademark on that. Smell, there's some perfumes that can get trademark protection. Taste, I don't know so much about that, but I'm trying to think of a good example for taste and touch, or those sorts of things. If there's something unique, something that can be used to identify source or create that association we've been talking about.
Like Kentucky Fried Chicken,
Um,
ingredients, secret ingredients.
The ingredient itself probably not, but I'm trying to think about like something, maybe like the Pringle shape, maybe something like that, the way it cracks. There's some things, I know there's some food stuffs that they do have a very particular sound they make. Speaking of sound, the Harley Davidson has a trademark on their motorcycle, the exhaust, which is kind of interesting. So again, it's kind of broad, and imagine it'll probably evolve after a while as more things. Maybe something will come up in a couple of years involving the internet where you can go ahead and some other new source identifier can come out. But again, it's just as long as you have that concept of tying your mark to the product, goodwill, generally you can get a mark in it. So choosing a trademark. Now this is what's interesting. There's all kinds of trademarks. We'll go through just a little where you're most likely to get protection, where you're not most likely, where you're least likely. So the most is something that's arbitrary or fanciful. Verizon. What does Verizon mean outside of Verizon? It doesn't mean anything. Kodak. It's not a word. It's something somebody came up with in order to get a mark. So you think about that, no one's ever used Verizon probably before Verizon came out, or Kodak before Kodak came out. That's pretty easy to get a mark in. Here's where it gets a little more interesting. You have something that's generic, green beans. Can't get it. It's tough to somehow get a trademark on green beans if you're describing green beans. Now if you're describing a car, green bean car, seems kind of weird. We'll get into that in a second, but maybe you can get a mark. But if you're trying to get the trademark green beans on green beans, probably not going to happen. Something that's descriptive, yellow pages. Okay, we're getting closer. You can get some protection. You get some pages in the phone book that are yellow. So it's really describing what they are, but after a while, they acquire this meaning. The public says, aha, the yellow pages, I know exactly what it is. That's a part of the phone book where I can look to go ahead and find businesses, or I can go on the internet. So after a while, they can go ahead and get protection on that because they've acquired this secondary meaning. They've got something beyond what just somebody says yellow pages, you instantly think about going to the phone book or maybe looking at the yellow piece of paper. Suggested, Microsoft. So this is, you're thinking about microcomputers, software, suggest what it is, and again, Microsoft on its own, that might be a trademark on its own, but again, acquiring the secondary meaning certainly helps it get over that line to move forward to actually getting a registration. And then arbitrary, Apple. This is kind of like the green beans. So Apple, for an Apple company, probably wouldn't work, but Apple for computer, smartphones, those sorts of things are more likely to be registered. So when there's companies actually out there that will help businesses come up with interesting marks. And sometimes you see them, they might spell a word wrong. Different, not the common spelling for word. Maybe instead of an S, they use a Z or something like that. Or they put the letter backwards, like kid, Toys R Us. They have the sort of backwards R. They can use that to get their mark because it's a little different. So trademark protection. Generally, like we said, common law, you'll get rights that are protected under the judicial law of the jurisdiction which you're in. It protects you the geographic area in which it's used. So you get, for your mark, you get your business area, basically what's ever reasonable for the scope of your business. Wherever people would say, I've seen that mark and I understand it's used in commerce in this area. And how do you get protection? All you have to do is use it. You don't have to do anything. You don't have to necessarily file with the Secretary of State. You can. Again, all these things are building on it. If you want to make your protection a little stronger, you file. If you file with the Secretary of State, that's better than the common law mark because you, by the way, have a piece of paper that says, here's my mark right here. If anybody ever tries to take it over or infringe on your mark. And also, it just shows, here's my data first use. I can show when I start using this mark, so somebody comes in after you, they can't say, I've got superior rights to you. You can say, no, I've got them because I've got this piece of paper that shows when I registered my mark. And then there's federal. This is where you go to the Patent and Trademark Office and go to the Trademark House. You file an application, an examiner will go ahead and examine it, and it does cost money to file. You have to identify your goods or services that you intend your mark to cover, And after a while, you go ahead and you get your mark, and once it actually, after a couple of years of use, you would actually be able to get the circle arc. You'd have the TM until it actually becomes a perfected mark, and then it's on the principal register, and then that gives you the rights with customs and all the other benefits we're talking about. So generally, just using your mark gets you the rights. If you want to go ahead, the next step I recommend is considering going to Secretary of State, because again, that's fairly easy. Unless you really see your business expanding or see a need for it, probably for small businesses, getting the federal registration is not necessary. So again, here's how you do it. You file your application, provide examples, description, your classification, your goods and services, and you pay a fee. Like anything with the government, you have to pay a fee.
What is USPTO?
United States Patent and Trademark Office.
Okay.
And that's in Alexandria, Virginia. And they actually just opened a branch down here as well. So again, this is what the examiner does when they go through. They actually, in the examination process, they want to make sure they look at a database of all these marks that are out there. They want to make sure it's not confusingly similar. They want to make sure that on that scale of when we went through from descriptive to suggestive to arbitrary, they want to see where it fits. They make sure it's not immoral, deceptive, or scandalous. The one thing that people think about that is the Redskins trademark, which has been apparently canceled. Which the irony there is that it's actually just going to increase the use of the mark, because now the Redskins can't stop people from using their mark anymore. So all the market's going to be flooded if the Redskins are. The examiner verifies the use or the intended use. It's published for opposition, and then if it passes that, the mark's registered. It's a 10-year term. And then at the end of that 10-year term, you have to go ahead and renew your registration. So the key thing here is, all the registration process is good. Going through that, it's good to know. But what you really want to be is, you want to be aware of the marks of others. You want to make sure, and when you're starting, you have a small business, you might have a name that sounds great. You want to try to do some research. Google is, again, a great way. Type in the name of your business that you might be looking at or might be using. See what comes up. And again, you don't want to, if there's somebody in the same area as you want to be careful. Because if the mark's valuable to them, they might come after you.
Excuse me.
Yeah.
Just curious. You're talking about the Redskins and how people are going to start to use it.
Mm-hmm.
So can somebody just set up shop and start printing it on shirts and then sell it?
Once the mark once it lost that federal registration, they can.
Really?
So they've lost complete protection over it, which is again the ironic thing. Do you think they want to shut down the use of the mark, but now that anybody can just go ahead and do it, why wouldn't?
And copyright doesn't come into that at all?
No, well, potentially on the, no, it wouldn't, because the copyright is actually more, and we'll get into that more, but copyright is more protecting the fixed impression of like a book or music or sound, but not a logo necessarily. So, when you're doing that, also you want to look, if you have a mark that's McDonald's, for instance. If you want to use McDonald's, probably not a good idea, especially if you're using it for hamburgers or food or clothing like we talked about. So you want to also look at potentially whether you have an issue with a larger company, and if somebody has a registered mark in there, you might want to talk to an attorney and see if you think if you're in the clear, there's some gray area. If you have maybe a tire company or money management company, you call it McDonald's, is that going to cause issues with McDonald's? Is anybody going to say McDonald's is somehow managing money? Now they're having breakfast all day long. I don't know, maybe they'll move into that, so who knows. And then you'll want to look at that infringement. You want to look if your mark is similar to the mark of an earlier user. Again, that can be common law, it can be registration with the Secretary of State, can be federal registered mark. Are they in the same area to describe related products? Again, marks can exist in different areas if they cover different things and are intended to protect different types of goods or services. So a lot of times they can coexist. And really, this is the key. Are the customers likely to be confused? When these cases come up, generally what happens is the company will go out there, the company that wants to shut down the other mark or sue somebody infringement will go and get a survey done. And the survey will go to the mall, they'll go out to the public, and they'll say, are you confused by these two marks? If somebody came up to you and said, this mark, are you going to associate it with this particular company? And if you know, overwhelming, these things can be developed, and generally they'll find the way they want them to find, and then the defendant will come back and say, no, I've got my own survey, and there's competing surveys, and then the jury tries to figure out what happens. And again, when you're using your mark, for a common law mark, TM, SM, only once you have the Federal Register mark can you use the circle R. If you use the circle R, you don't have a Federal Register mark, you can be subject to some penalties. So, don't do that. And then you want to, for your mark, once you have your mark, you want to go ahead and monitor. You want to see, is anybody using my mark? Or you want to police your own mark. You want to look around and say, somebody's trying to knock me off, and if they are, you send them a letter and say, stop it. And the other thing is you want to use your mark always properly, and you don't want to use it generic. And a famous example is a mark one day, a long time ago, was Escalator. That was actually a trademark. Escalator, where the company decided instead of using it as an adjective for a noun, they use it as a noun. So, like, another good example is Xerox machine. Luckily, that one hasn't been locked because they went ahead and protected it, but people would say, hey, I'm gonna go to the Xerox, I'm gonna Xerox this. Realtor is one that drives me crazy, because Realtor actually uses the mark wrong, yet somehow they won. They say, come see a Realtor for, you know, to sell your house.
Kleenex is one too, isn't it?
Kleenex is a mark,
Right.
it still is, but it's Kleenex brand tissue. So if you look at the way they're using it, it's interesting. You look, companies are smart. Kleenex brand tissue or facial tissue or something like that. They're trying to use it to describe the source of a source of origin, but they're not trying to use it as a noun. So you always want to make sure when you're using your mark, you don't want to use it as a noun, you want to use it as an adjective. And again, the evidence, if the evidence comes in that you're using it as a noun, you might lose rights in your mark even though you had it. Singer sewing machine, that's another one. I think they lost it, but I think they were able to recapture it at some point later on down the road. All right, copyright. So here's number 2. So circle C. Copyright protects against copying, modification, display of original works of authorship without the permission of the owner of the copyright work. So in other words, copying a photograph, you know, copying an MP3 or a song illegally, somebody has a copyright in. Copying a book, except when you have fair use for it. When you're using it for like in the library, taking a copy of a page or something. How is a copyright created? It basically automatically happens as soon as the original work is fixed in a tangible medium of expression. And what does that mean? It can mean anything. It can mean it's on the internet. It can mean it's in a picture. It can mean it's on music. It can be on a CD. It can be anywhere. It can be written on a windshield, I'm sure. So it's very broad. And again, the key for copyright is, so how long does copyright last? Copyright lasts for the life of an author plus 70 years or up to 120 years from the creation of the works made prior. Interesting story here. This is all because of Walt Disney. This time has been extended a number of times, the length of a copyright. And it's because after Walt Disney died, I think the time was much shorter, it was like 50 years. And then Disney got a little excited when it was like, oh, people are gonna be able to go ahead and knock off our copyrights, and then Mickey Mouse and all these sorts of things. So they petitioned, and the period got longer, and who knows, is that 120 years from when Walt Disney dies? For the 70 years, who knows if it's gonna change. I think Walt died in 1970 or so. So we've got a couple of years until they have to go ahead and go back to Congress and lobby for that. But it's funny, that's true story. That's exactly why they did that. It just shows the influence some companies can have on the way these things work. Copyright protects. So here we go, literary works, musical works, dramatic works, pantomime and choreographic works, pictorial and graphic works, sculptures, computer programs, motion pictures, sound recordings, architectural works. So yeah, Frank Lloyd Wright, I think, has a couple of, there's some architects, Frank Lloyd Webber, okay, right. Weber is the guy who did the musicals and stuff. Anyways, that's right the first time. But you know, he's got some copyrights in his in-house design, some of his product designs. So we'll cover anything. Yes.
I created a financial workbook, and one group told me I don't have to copyright it, and somebody told me I should.
Okay.
And the one group said, even if you copyright it, if they change a few things, then it doesn't mean it's a copyright.
That's true. So here we'll get into this. So copyright, to register a copyright, you don't need to do anything. The Copyright Office is located in the Library of Congress. And what you can do is you can submit something, you can submit a sample there, you can get your fellow registration. You don't need to do that. It basically happens as soon as the work of art is set in a tangible medium. So when you did your book, yes, you're right, you've got a copyright in that book. Now, they have to do more than just change a word. You can't, like, they capitalize an A instead of a lowercase a, or change some people. There's, it's one of those things where you have to kind of look at it and see what it is, but generally, if a substantial portion is reproduced, then you can run into potential liability. But again, it's always better to go ahead and do this on the bottom of your work, just to give people a notice that they can't just copyright this thing, even though you don't have to. Put your little circle C, the date that the work was created, and the name of your company, and the name of the individual, or whatever you want, whatever the owner of the mark would be.
So there's a really big case right now, I don't know if it's an actual case, but on Instagram, there are artists who put up their work. And another artist decided that they were going to take a screenshot of whatever work that they found that they liked. They took the screenshot, they printed the work, they blew it up, and they sold it for thousands of dollars. Obviously, the artists who created the original work, they were really mad because obviously they got credit, but they're not getting any of the profits. So is that a copyright infringement? Because technically he's changed the work by taking a screenshot of the work from Instagram.
Yeah, you've got two copyrights here. You've actually got the copyright in the sculpture or the art or the work, whatever it is, and you've got a copyright that the person takes a picture, which contains the other copyright work. Now, I'm not exactly sure how that one would shake out, since I am not a true copyright attorney, but I mean, it raises lots of issues. One of the about a year ago, there was an interesting picture. I can't remember what type, I think it was a gorilla. A gorilla took a selfie of itself, and somehow the gorilla got a cell phone and took a picture. And somebody was trying to claim, and went viral, went all over the internet, and the guy whose phone it was said, hey, this is mine, you can't reproduce that. No, because the gorilla actually was the one who, if anybody, owned that copyright. Now, that went back and forth, I can't exactly remember how that shook out, but that was the defense to everybody saying, you didn't actually take that picture. But then his argument was, well, I mean, can you really give a copyright to an animal? And I can't remember, I think they actually settled before that one, before the decision was made. That was an interesting case. I mean, those sorts of strange things, who actually owns a right in a gorilla taking a selfie? So, if a gorilla takes a selfie in the forest, anybody hear it? So basically, the copyright owner, like we said, controls reproduction, distribution, adaptation, public display, and public performance of that. So, in general, whoever owns the rights in the song could prevent somebody from, a band from doing a cover of it. And generally, that's why you see royalties that are flowing when a band goes out and does a cover of a song, a big band, they'll go ahead and they'll pay royalties because of that. Okay, bless you. Copyright ownership. Again, it generally, your employee, and this kind of ties on to what Alan was saying earlier, you want to go ahead and make sure that you've got your employee handbook and your employees are assigned to the extent that they are coming up with things. Computer programs are a great example, or photographs. You want to make sure that your employees are assigning their rights to you, to your company, because if there's a dispute as far as who owns the copyright, you want to have that document that says everything that you've done within the scope of your employment belongs to me. So that's for copyrights, it's for trademark, it's for patents and inventions and those sorts of things. Yes?
So is that automatic? So if my employee creates something, does that belong to the company?
For the most part, it does. It's within the scope of their employment, especially if their job is to do, to create a sculpture for you. Generally, yes. But you always want to make sure you have that belt and suspenders. You want to make sure you have that assignment in place. So you want to have them come out and here's your employment agreement. It's clear in here. Everything you come up with is assigned to me, and sign this, and therefore we don't have to ever have an issue with it. The guy can't say, well, I made this during off hours. It really wasn't in the scope of my employment. Wasn't asked to do it. I was doing something else. Just happened to come up with this cool design. You want to go ahead and protect yourself. So if you have employees that are inventing anything from patents, from inventions to maybe come up with a new trademark to doing some designing for you, especially if it's anything artistic, you wanna go ahead and have them assign the rights, or school photography. Music, yeah, any of those things. So again, there's that. So again, copyright registration, you don't need it. You have a common right, a common law registration, and just by using, once it's set in its handleable form. All right, what is a patent? And this is the part, if you have any sharp objects in your hands, please put them down, because I don't want anybody going down and getting hurt from me during this stuff. Patents, probably, I'll go through this quickly. This is what I do, but it's probably generally not what any of your businesses are concerned with, but I'll certainly just give you, so you know what they are down the road, just in case you hear it. So we've talked about two things. We talked about trademark, which is an indicator of origin. We talked about copyright, which is the fixed impression that's set in some sort of form. A patent protects ideas. A patent protects functionality. It protects basically anything that's new. Basically it protects a new, functional, useful, novel, non-obvious idea that has some sort of functionality with it. Basically, a patent is an agreement between the government and the inventor to go ahead for the inventor to go ahead and disclose to the government, to the patent office, an invention. In exchange for that, they get a certain period of exclusivity where they can exclude anybody from making, using, selling, importing their invention. So you hear about the Apple versus Samsung cases all the time. That's what that's all about. They want to try, Samsung has patents, Apple has patents. They want to try to exclude each other from certain features they may have on their smartphones. And that's what all those fights are about, because it's worth a lot of money. And they want to exclude, Apple wants to say, hey, Samsung, you can't use this shape of a phone because that's ours. We came up with that. And Samsung might say, well, you can't use our screen because we've got a screen, a home screen that looked like this, and you can't use that. We have a design patent to cover that. And somebody might say, well, you can't use this because you've got a certain Bluetooth transceiver that we invented, our memory, our batteries, or those sorts of things. Those are what patents cover, and that's what the goal of them is. You've got that period of exclusivity where you can control what people do with that technology. So what can be patented? Any new and useful process, machine, manufacture, composition, matter. Basically anything, it's got to be something that, like I just ran through a couple of them, computers, tires, processes, computer software, almost any plants, almost anything that you can invent.
What about a recipe?
A recipe? Potentially.
I had spoke with an attorney, he told me I couldn't, and I wanna check the work I do, I couldn't patent it because I have to be able to prove I'm the one who made the recipe, and it's hard because you have to teach other people how to run a business, and you're the only person, so how do you expand your business?
Generally, I mean, a recipe is tough because again, it's got to be something that's new and non-obvious. I mean, if you're taking, like for example, a biscuit recipe or something like that, where instead of we decided to put some Tabasco in there, it's going to be tough to get a patent on that, even if it's something that's completely unique. Food stuffs are tough. There's certain ones like Pringles has one on a potato chip. Actually, their potato chip because they grind it down into a certain powder. Then they have some other stuff you probably don't want to know what it is, but they use that to go ahead and stick it together, right?
I know.
So they can get a patent on that now. But that's more because it's the process of forming the shape of the particular of the potato chip. A general recipe, like if you came up with a new recipe for a cookie, and you said, oh, I'm going to go ahead and use candy corners instead of chocolate chips. It's going to be tough. And at the end of the day, it costs a lot to get a patent. And the real issue is it worth the investment? Is it going to get you something? Versus trying to establish, coming up with maybe a brand name for that particular cookie, and going ahead and trying to market it that way, establishing a secondary meaning, maybe a trademark.
I guess I'm trying to see how do you protect it?
How do you?
How do you protect the recipe?
A trade secret is probably the best example. That's a great point.
We just
Well,
talked about it.
Yeah, so a trade secret is you.
Like Coke, they
Yeah.
say the recipe.
You keep the recipe.
So maybe a trade secret.
You want to keep that recipe secret and control your employees. So it's not like you can say, okay, here's our secret recipe. Jim, Joan, and Tony, go ahead and go make it. If you don't trust those guys, you have to say, here's our secret recipe. I control it. Here, I'm going to go ahead and control who the one or two people that can actually come up with this recipe and be developed, actually make the cookies or whatever it happens to be. You can control that from a trade secret pretty, but you've got to make sure you put the adequate controls in there. And we'll get into trade secrets in a second. One thing on that recently, I don't know, it's exciting to me, probably nobody else, but Pepperidge Farms, who owns the Milano cookie, just recently sued Trader Joe's on the shape. They have a cookie, very similar looking, except it's, Milano is kind of like an oval or something, like round like that. Trader Joe's is more of a square cookie, same General Tyco cookie, same dark chocolate in there between it, or milk chocolate, whatever it happens to be, but they're trying to go ahead and shut down Trader Joe's, and I believe they're using trademark for that. So, just because they've acquired, over the years, you see a cookie like that, you say, Milano, Pepperidge Farm, and that's the kind of stuff that you can, it's interesting, you don't necessarily think about that, but yeah, you all these things you see all day, like there's a mark right there, I recognize that, and that's what we've been conditioned, that's a conditioned response. What isn't patentable? Natural phenomenon, abstract ideas, laws of nature, algorithms, unless if an algorithm itself, you just can't, Pythagoras couldn't get an algorithm couldn't get a patent on the Pythagorean theorem, if that's how you say it. But he couldn't, because that's just the idea. Now, if you take the Pythagorean theorem and you apply it to something else, a machine that maybe makes triangles, yeah, maybe you get a patent on that. It's actually a case where the one of the companies that came first, vulcanized rubber. It's a formula for your tires, how your rubber is developed and how it's cured and to make it super strong. That's a known, I think it's the Archimedes equation. That's a known equation, people have known it for a long time. A company said, well, you know what, we're gonna use that equation to control the mold when it opens and closes, and you have a computer run that, and from there, we can go ahead and get a patent on it. They're able to, because the algorithm was known, but they're able to use their algorithm to control machinery. So just I'll tell you, exciting patent attorney stuff. Boy, we're exciting. Perpetual motion machines. You couldn't, so something that just couldn't work. You couldn't get a patent on a lightsaber right now, I think, with Star Wars opening tonight, because it just couldn't happen. If you figured out how to do it, you could, or time travel. You've got all these ideas and how things could happen, but until you can actually show that you can do it, you can't get a patent. So again, there's different types of patents. Utility patent protects the functional features. 20 years from filing. Design patent protects ornamental features. So the Coca-Cola bottle could be one. That bottle right there could be one. Anything, internet pages could be that. And there's plant patents, which honestly I've never dealt with, so they just cover plants. Here's an example of what a patent looks like. This is on a writing apparatus. So it's a utility patent, it's got a number up there, it's got the name of the company, the inventor there, it's got the name of the company to which it's assigned, or it should, somewhere around there, but this one doesn't. Here's another one, this is a design patent, and again, this one's showing, and there's a bunch of claims in the document that actually goes ahead and is what claimed the property claim. This one, it's this shape. So if you have that shape, there, whoever the Jameson Sewing Machine Company owns that shape. And they can, if anybody wants to go ahead and make a sewing machine or anything that looks like that, they can stop them from doing that. We actually represent a company that had a golf cart once. EasyGo has a particular shape on their golf cart. And they were, there's a Chinese company that was coming in knocking off their golf carts. It was, they actually, I bought one of these things, brought it to a client. They took off the hood and the seats of their actual one, and they were able to do whole, part by part replacement for the Chinese one. So they went ahead and sued them, and they won, which was a big deal because they're claiming the design shape there. They're not claiming the functionality of the golf cart, but they were able to get it because they had knocked it off so blatantly. So that's a good idea for a design patent if you're looking to protect yourself from being knocked off by somebody. All right, 3 hurdles. It's got to be patentable subject matter, it's got to be new, and it's got to be non-obvious. I won't get into all this stuff because I know we're running up against the clock here. Is it new? What it just means is anybody else done it before. And usually you look at patent publications, articles, other patents. Was in public use. If you ever have an idea, here's the one takeaway from patents I think is the most important thing. If you have an idea that you think is patentable, write it down, write down your idea, get a date on it, have somebody witness it, sign it, and then don't tell too many people about it, because you have 1 year from the date of public disclosure. Whatever disclosure you make outside of your control, not under non-disclosure, to go ahead and file a patent application. After that, you're dead. So you cannot get a patent after that. So I've had a couple independent vendors come to me and they say, I've got this idea. It's okay, when did you come up with it? 3 years ago. All right, did you tell anybody about it? Yeah, I told so-and-so about it. You know, my wife, children might be different, but yeah, I went to my buddy who runs a manufacturing company and I told him about it and we just lost track. 3 years went by. That disclosure kills you and you won't be able to get a patent there. So if you have something that comes up that could be patented, you wanna go ahead and move, you've got that 1 year period in which to operate from that date of disclosure. You can continue to refine it, but once you've actually tried to offer, sell, or you've had a public disclosure, that's the end of your ability to get a patent. All right, so again, patent, basically you can do a patentability search, you can do this on the government's website, which is www.uspto.gov. I recommend seeing a patent attorney just because it is complex, and I'm not trying to drum up business, but it's a very complex process, and I've been doing this for 18 years, and you still learn things every day. There's certain ways of claiming things, there's a lot of mistakes, there's a lot of places that things can go wrong. Getting a patent, so you file and prosecute that, and convince the patent office that it's allowable, and it generally takes 2 to 3 years for that process to happen. Oh, here's one key point. A patent doesn't give the invention the right to actually practice it. It gives you the right to exclude others. So you might have a patent on something, like you have a patent on a 4-wheeled car. Somebody might have a patent on a 3-wheeled car. If you have the patent on the 4-wheeled car, if they have the 3, you might, if the claim is written in such a way that prevents you from doing the 4-wheeled car, you might not be able to practice your own invention without paying the royalties. Trade secrets, again, formulas, patterns, devices, or combinations of information that's used in the business, and because it's unknown to others, gives you a competitive advantage. So your strategy is you identify your valuable confidential information, business plans, customer lists, technical product and process information, recipes. You take steps to keep that confidential. You use confidentiality agreements with your employees, your vendors, your contractors, anyone who might have access to that, making sure they know, hey, this is a secret. Don't go ahead and misuse this. And make sure your employees know what the information is, why it's confidential, what information is confidential, and the importance of keeping a secret. This recipe is our bread and butter. This is how we make everything that we make. You cannot let other people have. You can't let the Waffle House down the street have this recipe because they'll knock it off and we'll lose the rights in our much superior waffles, which is hard to believe. There's better waffles than Waffle House. Strategies for trade secret protection. Again, restricting the access to a certain number of key employees. Mark your documents that have them with with the trade secrets with the company's name or that has a trade secret. Isolate and protect your most important trade secrets and maintain computer secrecy. Again, if you think about the Coca-Cola formula, how they protect it, the big vault, you don't have to go that far, but move towards that. So takeaways. Basically from this, I just think about what potential intellectual property your company might have, if any. Copyrights, trademarks, trade secrets, patents. Use the trademarks to your advantage. Secure your patent rights and new and useful inventions. Protect your confidential information. And avoid, perhaps the most important thing, avoid the patents, trademarks, and trade secrets of others. You don't want to go ahead and run into a fight because, again, this stuff gets expensive and it could end up putting your business out of business. Thanks very much. I appreciate your time. And again, that's a 404 because I'm from Atlanta. Even though I don't sound like it, I don't have an accent. I'm actually from upstate New York, so I'm a transplant. So I don't know which one you all picked. I guess I got picked on because I have a tie on. I guess, I don't know. Maybe I'm not counting for Texas. Thanks very much.
Thank you.